Some Talk, the podcast. I'm Shashti Floor, journalist, Hollywood troublemaker, and your favorite voice of reason
In the unpredictable and often cutthroat world of high-profile litigation, particularly when narcissistic personalities are involved, there exists one golden rule, a rule that independent journalists, public figures, and those with any degree of public visibility often learn the hard way. And that rule is simple: do not take the bait. This isn't just a catchy phrase tossed around as friendly advice. It's a survival mechanism both inside and outside the courtroom. When you are engaged in a legal dispute with someone whose behaviors align with narcissistic traits, every word, every reaction, every emotional response you give them becomes a weapon they can twist, distort, and strategically use to frame you as the villain in the narrative they're constructing. The moment you lash out, even if provoked or cornered, that reaction becomes the centerpiece of their case, and the longer the case drags on, the more that manipulated version of events solidifies in the minds of judges, observers, and the court of public opinion. Over time, repeated enough, these narratives, no matter how false, can start to seem plausible to those tasked with deciding the outcome. In the context of the ongoing, high-profile, emotionally charged litigation involving Blake Lively, her attorneys, and the parties connected to Wayfair, the public filings have revealed a deliberate, almost calculated effort to build an image of Lively as a victim, a wronged individual besieged by dangerous, abusive, and vengeful forces, which in her narrative include powerhouse attorney Bryan Freedman, business interests linked to Wayfair, and Hollywood figure Justin Baldoni. Lively's legal team has meticulously crafted a portrayal in which everything occurring online against her, from critical social media posts to investigative commentary, is framed as a coordinated smear campaign, a retaliatory attack stemming from her decision to take legal action. In this framing, even the mere fact that the defendants choose to defend themselves is characterized as further aggression, an abuse of the court's docket to cause her harm. And underlying this dynamic, one can't ignore the suggestion, voiced by many closely following the proceedings, that the resources fueling this relentless litigation appear to be bottomless, with speculation that Reynolds, Lively's husband and an influential Hollywood figure in his own right, is willing to spend whatever it takes to crush those in his and Lively's crosshairs, with Blake positioned as the public-facing shield, for a lawsuit that may in reality be more his battle than hers. That's the opinion some commentators have drawn, that this case is less about personal grievance and more about a broader vendetta. When you're on the receiving end of litigation driven by a person or team operating with such a psychological edge, the process is more than exhausting. It's designed to wear you down. Mistakes will happen. They're inevitable in high-pressure legal warfare. And in this case, every small slip-up by the Wayfair side has been immediately seized upon by Lively's attorneys, turned into a point of leverage, and presented in a way that makes the opposing party appear reckless, malicious, or incompetent. In moments where the Wayfair camp, which includes Freedman and Baldoni, has reacted out of frustration or in an effort to defend themselves, Lively's side has pounced with precision, magnifying those actions into evidence of aggression. Meanwhile, the Wayfair side has often avoided filing motions for sanctions or asking the court to discipline Lively's team, instead taking a reactive, defensive posture that may stem from a combination of strategic caution and personal disposition, particularly in Baldoni's case, where his known faith and do no harm philosophy discourages aggressive retaliation. Yet in this asymmetric dynamic, passivity becomes a disadvantage. Every time they choose not to counterattack, Lively's legal machine uses the opportunity to advance their own aggressive filings, unencumbered by reciprocal challenges. This imbalance became especially evident in a recent dispute over the handling of deposition transcripts. I had predicted earlier in the week that it would not be surprising if the judge ordered the striking of the full deposition transcript from the record, because typically, in motion practice, you don't upload the entirety of a deposition unless every word is relevant. And that's almost never the case. Normally, you would excerpt just the pages or passages pertinent to the specific motion, usually 2 or 3 pages at most. Yet here, Wayfair's team attached the entire 292-page uncertified transcript, which, from a procedural standpoint, was unusual enough to draw the court's attention. As anticipated, the judge did in fact strike it, agreeing with Lively's motion that including the full transcript served no proper litigation purpose and instead burdened her while potentially inviting public speculation and scandal. In his reasoning, the judge pointed out that Wayfair had not even attempted to argue for the relevance of the entire document, nor could they plausibly do so. While he stopped short of labeling it abusive, he framed the inclusion as improper, part of a pattern where filings are used to litigate the case in the media rather than strictly within the court. This interpretation, whether one agrees or not, fed directly into Lively's narrative that she is being targeted and harassed through procedural gamesmanship. The court's ruling was sharp. Attaching the entire transcript after citing only 2 pages was unnecessary and improper. By doing so, the judge suggested, Wayfair may have been positioning themselves to force Lively into filing a motion to seal or redact, which they could then spin for public relations purposes, for example, by claiming she was trying to hide damaging testimony. In this view, the move wasn't about the merits of the case, but about shaping public perception. Whether or not that was Wayfair's intention, the judge took the position that his role included preventing the court's docket from being used to fuel personal vendettas or generate public scandal, and so the deposition was struck, with only the relevant sentences unredacted and preserved. The irony here is that, on the other side, Lively's team has also filed materials that could be considered disparaging or inflammatory, yet Wayfair's attorneys have not sought to have those struck, again reflecting their more restrained approach. What made it into the record before the strike was telling. Under questioning by Freedman, Lively admitted that the only ongoing smear campaign she personally knew of was the so-called retaliatory lawsuit itself and the press statements made by Freedman about her and her character. That admission underscores the personal, reputational stakes at play for all sides. But beyond the legal maneuvers, there's a very human cost to this kind of litigation. Being in a protracted legal fight with someone who employs relentless gamesmanship, who uses every misstep against you, wears down not just the litigants but their legal teams. Attorneys on the receiving end of Lively's counsel's tactics some describe as uncooperative, domineering, and uncompromising, inevitably find themselves under extreme stress. The dynamic is simple. It's their way or no way, and any resistance is met with escalation, for Wayfair's side, that has meant months of fatigue, constant public disparagement, and the psychological strain of fighting a battle where every defensive move is reframed as an attack. This environment isn't just affecting the named parties. Even journalists and commentators covering the case, myself included, have been pulled into the fray. Recently, my name was brought into the mix when Perez Hilton, another high-profile media figure, shared a screenshot from my Instagram noting that the subpoena against me had been withdrawn. While my intent in posting was simply to inform my audience that the subpoena, which my legal team believed was improper, had been dropped, Perez's use of it to illustrate what he viewed as abuse of process by Lively's team created an opening for her side to question the context, framing my statement as unverified and downplaying the implications of the subpoena's withdrawal. From my perspective, the withdrawal spoke volumes. If the subpoena had been valid, why retract it the day before we were set to file a motion to quash? But engaging in that back and forth publicly risks being cast as retaliatory, and I've learned that defending oneself in these situations often backfires, feeding the very narrative the opposing side wants to promote. Perez, for his part, has faced his own share of stress from this case, filing multiple documents in court and becoming a target of ire from some who feel his responses inadvertently bolstered Lively's victim narrative. While I understand the frustrations of those critics, I also recognize that Perez has been an ally in my reporting, publicly defending me and corroborating the patterns of behavior I've described based on his own sources. He stood up for me against attempts at intimidation, and I won't disparage him for how he chooses to handle his own legal entanglements. One of his more colorful filings, addressed directly to Judge Lyman, illustrates both his personality and the strain of representing oneself in such a hostile environment. In it, Perez half-jokingly refers to the judge as sexy and smart, calls Lively's attorney disgraceful, and openly accuses them of misrepresenting the truth, all while requesting sanctions and attorney's fees despite representing himself. The letter also points out that he's filed a motion to quash the subpoena in Nevada, framing it as burdensome and unethical, and asserts his rights as a journalist to protect privileged information. While his tone may strike some as irreverent, the underlying message is one of frustration with what he sees as abuse of legal process and a determination to fight back, even without formal counsel. All of this, the aggressive filings, the strategic narrative building, the tactical passivity of one side contrasted with the unrelenting offense of the other, creates a perfect storm where the actual merits of the case risk being overshadowed by procedural skirmishes and media battles. In such an environment, not taking the bait becomes both more important and more difficult. Every decision, every filing, every public statement becomes a potential weapon for the other side. And for those who've been through it, the lesson is clear. In the court of law, as in the court of public opinion, restraint can be as powerful as action, but only if you